This is Rehan Ali Muhammad with another edition of Do You Know the Laws? Today we're going to be talking about the different types of business entities, what you need to know about them, and some different tax advantages and disadvantages between the two. So the main thing is there are many different business entities. A lot of them differ by state, so you need to check your state rules because a lot of this depends on what state you live in. For example, many corporations incorporate in Delaware because some of their rules are more advantageous than other states. So you need to make sure that you do check the rules in your state or talk to a qualified attorney. The other thing is, regardless of what type of entity you create, you should always have everything in writing, even if it's on a paper napkin. I've seen some cases where some people put it on a napkin and that saved them from $1 million of losses. So I'm not suggesting a paper napkin, but that just basically illustrates my point of everything needs to be in writing. When you create a partnership with someone, you need to have an exit plan because a lot of times partners end up leaving on bad terms, and if it's in writing how it's going to be handled, then it just makes it a lot easier. You save a lot of money down the road, and it's a lot clearer to everybody. So the first type of entity we're going to talk about is a sole proprietorship, and that is the most basic form and the most original form of business. And if you do not incorporate, if you do not create a partnership, then your business is a sole proprietorship whether you know it or not. What that means is there's no distinction between you and the company. For example, if the company gets sued or if the company violates an agreement, if it's a sole proprietorship, the creditor can come after you personally as the business owner and they can get some personal assets of yours. There's no distinction between the business and the individual. So that's the most important thing to know about the sole proprietorship. You obviously have to pay self-employment tax, Medicaid, Social Security, things like that. But again, that's the most basic form, not always the best form. A general partnership is also a very common, very old style of entity. And basically what that is, it's a partnership where there's no agreement where one party is going to be limited. Basically what that means is if the partnership is sued on an agreement, then all the partners are generally equally liable. So they can fully and severally liable. So that means basically if one partner has a big bank account and the other parties do not, the other partners do not, and a contract is breached by the partnership, they can go after the entire amount from the general partner who has the big bank account. So obviously again, it doesn't protect you, it doesn't protect your personal assets, and it also, all the income and liabilities pass through to the partners, similar to a sole proprietorship. So the next one is a limited partnership where you do have some of the restrictions as far as who's liable for what. The general partner in a limited partnership is still the one who is generally liable and the one who makes all the decisions or most of the decisions on a day-to-day basis. A limited partner is generally only liable up to the amount of their investment, unless otherwise written. So very important to have it in a partnership agreement, so it's very clear who is liable for what and who is allowed to make what decisions in the business. A limited liability company is obviously very common. Again, it was created to protect people from the general and the common business entities and the disadvantages of those that we've talked about in a general partnership or a sole proprietorship. A limited liability company, if done right, can protect you, protect the shareholder from a business liability. Again, it's very important that if it's done right, for example, if you do what's called piercing the corporate veil, what happens is if a shareholder treats the corporation as their own personal bank account and they do not treat it as a separate entity, then a court could pierce the corporate veil and you could be liable on your personal assets for a business liability. but again, if it's done right, you could be protected. Now, a problem with the LLC is that you need to remember the tax consequences. Now, with an LLC, you can choose to be taxed as a sole proprietorship or a partnership. So again, you need to talk to someone when you create this to make sure that you made the appropriate elections. An LLP is very similar to an LLC. However, it's the limited liability partnership, and you would not be liable for another party's actions as you would be in a general partnership. And again, it is a partnership for tax purposes, so your income and liabilities are passed through to your personal tax return. A C corporation, again, very common, and again, like I mentioned in the LLC, if it's done right and the corporate veil is not pierced, then your personal assets would be protected and would be separate from the corporate liabilities. However, a big disadvantage for C corporation is that there's double taxation. Basically what that means is the corporation, the C Corp, is taxed on their income throughout the year. And then as a shareholder, if you take distributions or dividends out of the company, you are also taxed on that. So that's why it's double taxation. A solution to that double taxation problem is what's called the S corporation. The S corporation is very similar, but as far as tax purposes, it can be treated as a pass-through to the shareholders, and you avoid that double taxation problem where it's not taxed, the company is not taxed on its personal income, everything flows through to the shareholders, and then you have to pay taxes only one time. So that is one way to go around the double taxation problem of a regular C Corp. You do have to make an election to create an S Corp within a certain amount of time. You could do it later, but you have to go back and do some work. And also, there's a restriction as far as who can be a shareholder for S corporations. Only certain individuals and only U.S. citizens can be shareholders, and there's a limit to how many shareholders that can be for an S Corp. Again, you need to look at your particular state rules. So again, it's important to pick the right entity. You can always change over. You may have some tax consequences, but you need to make sure that you pick the right entity as far as what kind of advantages and disadvantages are important to you. And the tax advantages and disadvantages you need to be aware of as also. And just like in contracts with corporations or partnerships or sole proprietorships or any type of business entity, it's very important to have things in writing. So this is another edition of Do You Know the Laws? And my name is Rehan Ali Muhammad. Thanks.